Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living here in Utah. Today we're continuing this video series about estate planning for different people at different stages of life. And this one is about singles who do have assets and or children. As far as children go, we've covered in multiple videos how to plan for them and the different considerations there. But for singles specifically who have assets, there's a lot more than just the children we need to worry about, because there is not someone that's necessarily the obvious choice for taking over financial or healthcare decision making if you're ever unable to do so for yourself. For example, someone who is single and has a child, if that child is a minor, and then it may well be a parent that is one of two parents that could be the default decision maker for healthcare and financial decisions for that person. It could be a sibling, it could be an aunt or uncle or cousins. It really depends on what the family structure is and who is around and who's available. So the importance there is to have an estate plan in place to make those decisions known rather than letting the law dictate those decisions. For example, a single individual might want a trusted friend or maybe a long-term partner as their decision maker instead of a parent or a sibling. Or maybe there's one sibling that they would rather have making those decisions over other siblings that may not be as responsible financially, but would otherwise be an obvious choice. Whatever the circumstance, a single individual who has assets does need somebody who has authority to manage those, whether they've passed away or become incapacitated. This can be done through a power of attorney, as we've discussed in other videos. It can be done through a healthcare directive for the medical decisions. There may be a last will and testament for dictating what happens to assets after they pass away, or it may make more sense for a trust. As we talked about in our young married couple video, a single individual may want to consider a trust if they own real estate, or if their estate does not have enough liquid assets available to be able to keep the estate afloat until administration by the courts can be accomplished. So that's like a 4 to 6 month period. If you don't have enough liquid assets that can last 4 to 6 months before the estate can be administered, it's probably something to think about. Anyway, thanks for watching. If you have any questions, feel free to reach out to us at any time, 435-572-0807.